Fifth Estate wanted to do a story about Ashley Smith and her journey through the prison system. And we knew that there was a preliminary inquiry in Ontario where charges had been heard, and it was decided not to proceed. We knew that the video from the Ontario institution where she died was played there. And we also knew that there was a trial that took place regarding her stay in a facility in Saskatchewan. The trial was in Saskatchewan of a man who was accused of assaulting her while in custody. And the video was played at that trial. So we made an application to get access to this and to copy this material based on a fundamental principle in law, the open court principle, which allows the media to not only view the material while it's being shown in court, but also to copy it and to broadcast it to the public, make it available to those people who are entitled to be in the room but couldn't make it for some reason. So we brought those applications and we met stiff resistance. As will become evident to anyone who sees the material, people who are involved in the proceeding clearly would not want themselves and their actions to be scrutinized in the way that the public process would subject them to. And as a result, we can only assume that's why Corrections Canada fought us at every turn. And we were partially successful in Saskatchewan at the outset. The judge at the trial said that we should have access to what was played in open court, but not what was filed in evidence, but was not played in open court. That obviously gave us access to a limited amount of material, but not everything that ought to have been, in our view, publicly available. In Ontario, we met stiffer resistance because we were able to apply the principle, but the exhibits had been given since the preliminary inquiry was over. The exhibits had been given to the custody of the Office of the Chief Coroner, who was going to be looking into the death. And the coroner's position was that we shouldn't get access to the video until they had finished their process. Our view was that the public was entitled to go to the courtroom to see it. We should be able to give the public what they could see and what we've already been able to report on in a word-for-word fashion, but we wanted to be able to show it to the public as if they were able to be in the room. So at first instance, the provincial court judge said that he was persuaded that we had a good open court principle argument, but was concerned that the coroner's process was something that he should defer to. We appealed that and got a ruling that didn't assist us in getting to all of the exhibits that had been filed, and so we appealed that to the Ontario Court of Appeal, which finally gave us a wonderful ruling that will serve us very well in the future. We didn't set out on this journey to make a precedent, but we are gratified that we were able to get a ruling from the highest court in Ontario that sets out very clear ground rules about how you get access to an exhibit and what the tests are. Well, it means a number of things. First of all, there can be no ambiguity about what test applies. We now know quite clearly that a test that the Supreme Court of Canada issued 15 years ago in the Dagenet case applies to our access to exhibits. So that's number one. I note that the Toronto Star recently took the Court of Appeal judgment in hand and tried to get open access to exhibits recently in a number of courts in Ontario, and were only partially successful. And the problem is that the policy of the Attorney General of Ontario has to be amended to accord with 15-year-old law which is the Dajne-Mentuck case. The presumption, once again, is that the public is entitled to access unless there's an order denying that access. Clearly, the ruling's been brought to the attention of the Attorney General of Ontario. It is the highest court in Ontario, and it shouldn't be up to the media or citizens to make expensive, time-consuming applications to get access to justice. They should be entitled to inspect public exhibits, publicly filed exhibits. And maybe that message is getting through. We were able, in the Williams case, to work with the representatives of the Attorney General of Ontario there in getting really quite full access to the proceedings. We were able to use BlackBerries in court to transmit what was being said live. We were able to ensure that the public who attended had access to all of the exhibits that were filed and could see them. We were able to get copies and broadcast copies of some very important exhibits that were there, including, on the Fifth Estate, as you know, the confession tape that was played in open court from Mr. Williams. So the openness principle is gradually being honored and respected. We've been establishing precedents now, quite significant precedents from the Supreme Court of Canada, now the Ontario Court of Appeal in this field, and we're hoping that the message will get through to those who have custody of exhibits, that the rule is openness and the exception is restrictions. This was a very important victory. It took us, as you know, 5 attempts to get a court, and we've got the Ontario Court of Appeal, the highest court in Ontario, to confirm for us that openness doesn't just apply to the ability to come into the courtroom to see what's going on. It applies to the ability to copy exhibits, to broadcast exhibits, and not only the portion of the exhibit that is played in open court, but the entire exhibit that is filed with the court, because that's the record on which the judge relies to make his ruling. Well, I think you only have to watch the Fifth Estate to see. Video, some people say, well, why is video important? Reporters can go into the room, they can tell us what happened, they can write a few words down and we can read them. Video, I think, when it's available, makes a meaningful discussion of court cases possible. It really does. It informs public debate. It creates the debate. It shapes the debate. It focuses the debate. And it creates what really is a meaningful public discussion about the court case in question. It draws people's attention to court cases in a way that's really essential for public discussion. We probably wouldn't be discussing the Ashley Smith case on the Fifth Estate and as much in the media generally if it wasn't because the Fifth Estate wanted to get access to this video and was able to get it. There are examples in recent memory of the importance of video to public discussion, not just the Ashley Smith case. We all remember the Jacansky video in the Vancouver airport. That was showing a person who died. And we all feel very badly. In fact, CBC, when that video was first made available, was reticent to show it all out of deference to all concerned. But that video was played quite a bit because it was a way of analyzing the case, understanding the case, humanizing what happened. And the video really probably led to the public inquiry that evaluated what happened there. Video has a powerful effect and a very useful public effect. And there are other examples. I've already referred to the Williams confession tape, which riveted audiences. The police ability to interrogate him is something that would take a book to explain if somebody wanted to sit down and read that book. But they say a picture's worth 1,000 words, and the deft interrogation technique by the OPP officer involved was there for people to see, appreciate, and understand. Video has a real capacity for helping us understand what happens in the court process and reminding us that the court system is not just about resolving dry disputes. It's about solving human problems. It's a forum where our most difficult issues are resolved, and it's a place where society is able to see justice and satisfy itself that justice is done. There are natural concerns that people have about whether the video of a person dying in disturbing circumstances is something that should be shown to the public. One of the judges in this case, the judge in Ontario who ruled before the Ontario Court of Appeal overruled him, thought that this was something that he did not feel should be broadcast to the general public. The Court of Appeal overruled him because they said it's not up to a judge to decide on that basis whether the public should get access to what is a public exhibit. There has to be a demonstration of harm to a legally protected interest. But just because we get access to it doesn't mean that we automatically want to broadcast it. We have standards that we apply, and we certainly want journalistically to present any such material in the most sensitive manner. In this case, our task was supported, very importantly, by Ashley Smith's mother, who felt it was important that the public see this. And I think that the Fifth Estate program that everyone's able to see will demonstrate that we've treated this subject in as sensitive a manner as you can.